Hi, you're here today with Joe Wallace. I am the producer of The Joe Wallace Show. We've been broadcasting in Southeast Queens for several years now. Today we're going to talk about the foreclosure process as it relates to the court system. First, a little background about myself. In addition to being the producer of The Joe Wallace Show, I publish a community newspaper called The Opportunity. I also have a foreclosure business called North American Foreclosure Solutions. In addition to that, I'm the author of a book called the Stop Foreclosure Auction Toolbox, which teaches people in foreclosure how to go into court to either stop, dismiss, or delay the foreclosure process. It teaches a person in foreclosure how to exercise their rights in court, which many people are unaware of, that there are a lot of things that one can do in court to challenge the foreclosure process. A little more background about myself. I was born and raised in New York City. My parents are from New Orleans, Louisiana. That's where the hurricane hit, Hurricane Katrina. Both of them came to New York before I was born, and shortly after they came to New York, I was born in Brooklyn, and then we moved out to Jamaica, Queens when I was a very young child. Been here all my life since then. Getting into the subject matter, the foreclosure process in certain states must go through the court system. There are some states where the foreclosure process does not have to go through the court system, and in those states the foreclosure process proceeds very quickly. The states that require the bank to go into court, the foreclosure process takes a little more time. The states that require court action are called judicial states, and the states that don't require the bank to go into court are called non-judicial states. The state of New York is a judicial state, which means that anywhere in the state of New York, if a bank wishes to foreclose on a home, they must go through the court process. So what happens with foreclosure? Basically, when the bank sees that the homeowner is missing payments, it could be one payment, usually it's two or three at least, and usually over an extended period of time, the bank will finally put their foot down and decide that they want their money back and that they're going to take legal action, also known as starting the foreclosure process. And that's when they formally start the foreclosure process. Now, certain things happen when you are formally in the foreclosure process. For one thing, the bank stops accepting money. If you send once the foreclosure process starts, you send your monthly mortgage payment and the bank will send it right back. And the reason for that is, to start the foreclosure process, the bank has to hire lawyers and go into court. They file what's called the list pendants, and they also start the process with something called a summons and complaint. So they go through a lot of trouble to start this process. If they accept payments from the homeowner after that process started, the process is canceled. So that's why the bank will not accept your money once the foreclosure process starts. Now, before we go any further, there's a very important point that I want to make about what happens when the bank stops accepting your payments. This is the most important thing I'm going to say in the whole show. Put that money aside. If the bank stops accepting your payments, don't go on a spending spree. Now all of a sudden you have an extra, whatever your mortgage payment is, you have that amount of money at your disposal, and some people go to the shopping mall. The bank is not accepting their payment, so they go out and buy a TV or buy some new clothes. I really want to emphasize that that is the wrong thing to do. When the bank stops accepting your payments, it's very, very important to put that money aside. Open up a separate savings account and put that mortgage payment in that savings account just like you were paying it to the bank. And the reason for that is, as the foreclosure process moves along, there are a lot of different possibilities of working something out with the bank. And if you have no money, if you've spent all of those months of mortgage payments and you did not set it aside, when it comes time to work out something with the bank, they're almost always going to ask for some kind of good faith payment, and it could be substantial. For example, if several months have passed while you're in foreclosure and you haven't been making the payments, now you owe the bank $30,000 or $40,000. if you're going to do a workout agreement with them, they're going to want $10,000 or $15,000 down. And if you've spent all your mortgage payments during those months, you will have nothing to give them. So it's very important to set that money aside. It's a very powerful negotiating tool as you move forward and you're trying to work something out with the bank. But to continue with the court process, the first steps are the bank goes into New York State Supreme Court in the state of New York, which is a judicial state, and files what's called a summons and complaint. And they also file something called a lis pendens. Lis pendens is simply notice to the court and the world at large that a lawsuit or an action is pending against that particular property. The summons and complaint, though, more important, is notification to the homeowner that they must appear in court to answer the foreclosure lawsuit. And the other mistake a lot of people make is they do nothing when they get the summons and complaint. It's another very important message is that when you get the summons and complaint, you will be served with that. Someone will knock on your door or they'll mail it to you. They have to, by law, they have to serve you with that paperwork. When you get that paperwork, it's very important to make a plan of action and decide what you're going to do and how you're going to proceed, because if you do nothing, the foreclosure process will move through the court system unchallenged. And what happens is eventually the court will award the bank a judgment of foreclosure. If you do nothing, that's what's going to happen. So what happens in that case is that once a judgment is awarded, a lot of the legal remedies that you have at your disposal to challenge the foreclosure action are canceled or waived. Once that foreclosure lawsuit goes into judgment, that's when you have a bigger problem. It doesn't mean it's the end of the world. It doesn't mean you have no other options. But a lot of the things you can do legally stop once that case goes into judgment. An example is many people have gone into court to fight a parking ticket. And you know what they tell you. The judge there says, well, that ticket's in judgment. There's nothing that can be done. Have you had that experience? When you go to fight a parking ticket. Now, if the ticket is not in judgment, you can get a reduction in the amount that's owed. You might be able to get the ticket dismissed if you have a good defense. But once that ticket is in judgment, no matter what your defense is, the court will not hear it, because judgment means a certain finality to any kind of defense that you can raise to challenge that particular issue. So the second important point is, as the foreclosure lawsuit moves through the court process, if you do nothing, eventually it will go into judgment. That usually takes anywhere from 6 months to even up to a year for it to hit the judgment phase, because a lot of things have to be done in the intervening time. So you have time to answer your foreclosure. Formally, there's an official time period where you can put an answer in. But even if you miss that time period, as long as the foreclosure is not in judgment, there's a lot of things you can do in court to challenge that foreclosure lawsuit. The next thing after the judgment is awarded to the bank is that it'll take a few more months to reach the point where the court gives the bank permission to sell the home at the public auction. That's when you are supposed to get a notice of sale, and again, that should be served. Someone will knock on your door and let you know, or they'll mail you a certified mail that your house has been scheduled for auction. Once again, if you do nothing, the house will be auctioned, and after that, there's almost nothing you can do. Although again, there are things you can do, but it's very limited once the house is sold at auction. Then within 2 or 3 months after that, if you don't voluntarily leave, the bank will go into court and get a judgment of eviction, which gives them permission to evict you, and then the marshal will come and take out your possessions and put them in a storage truck and put them in storage, and you'll be locked out of your home, and that's it. Deal is over completely at that point. Again, between the time of judgment and the time your house goes for auction, there are things that can be done to stop this. Now, to continue, going back to the beginning, where the bank first starts the foreclosure action, let's talk a little bit about service, about being served. It's a very important concept in the law. You have to be served with anytime anyone takes legal action against you, they have to notify you, and you have to be served with notice of that legal action. So usually in cases where the bank has started the foreclosure process, the first thing that's going to happen is you're going to get something called the summons and complaint. The summons tells you that you must come to court to answer this lawsuit, and it tells you how much time you have to answer. And then the complaint is a list of the reasons that the bank feels they have a right to foreclose on your home. Now, once again, if you do nothing, the bank gets everything they ask for in court. So at the time that you receive the summons and complaint, there are several things you should be thinking about. One is paying attention to how that service takes place. How were you served? Did someone knock on your door and personally hand deliver a package to you? That's called personal service. Another way that the bank is allowed to serve is by mailing the paperwork. But here's an important point. If there are any defects in the way that you were served, you can have that foreclosure lawsuit dismissed, thrown out. The bank has to start all over again and serve you properly. So pay attention to the way you were served. If they serve your next door neighbor, and your next door neighbor, let's say they serve your next door neighbor by mistake and your next door neighbor drops the papers off, you can go into court and say you were not properly served because they made a mistake in how they served you. Or maybe they serve an underage child in the property. There's a lot of things. Process servers make mistakes all the time. So that's something to pay attention to. How were you served? A lot of people ask me, well, should they open the door when they see a stranger standing on the doorstep with some papers? That's something for you to decide, but again, if there are any defects in the service, you can use that in court later on to have the entire case dismissed. Now, moving forward, the interesting news is that it's been found, and we've been saying this for years, we've been going into court helping homeowners fight foreclosures for many years under our company, North American Foreclosure Solutions. In fact, we've written a book about it, and many of our clients are lawyers. We write the legal defenses for several lawyers who then go into court with that paperwork and challenge foreclosure lawsuits. And what's been happening is the banks have been handing in very sloppy paperwork. The paperwork is often filled with defects. That's why it's important to make a plan of action when you get that summons and complaint. A lawyer will be able to look at your case. He'll look at all the facts of your foreclosure case, look at the paperwork, and a lawyer will look for the defects. We show you how to do that yourself in our book, The Stop Foreclosure Auction Toolbox. Some people would rather have a lawyer. Other people don't have money to hire a lawyer. That's why we wrote the book, so that you can figure this out yourself. You can look for certain defects in the foreclosure paperwork and challenge the bank in court. What's been happening is that the courts have been finding so many defects in the foreclosure paperwork. You might have been hearing about this on the news, that the new filings of foreclosures have slowed down dramatically because the banks have been using these automated services to prepare their court paperwork, and they have been making a lot of mistakes. So when the bank goes into court to start this foreclosure process against you, when they hand in that paperwork, if there are mistakes in that paperwork and you come and challenge those mistakes, you come and say, I found, that the bank was not really holding title to the mortgage at the time they started the foreclosure lawsuit, that foreclosure lawsuit can be dismissed. At the very least, you're going to delay the process by several months by going into court and challenging defects within the foreclosure paperwork.